morning.
Good morning. May it please the court. My name is Samit Chagani, and I represent the appellants in this matter. The appellants would like to reserve 2 minutes for rebuttal.
Okay.
The factual findings contained in the lower court's order tell the story of this appeal. Plaintiff filed 2 identical complaints on separate days. After determining which judges were assigned to those cases, plaintiff then selected the judge it preferred to hear its case. Plaintiff then voluntarily dismissed.
Or is that a supposition based on the fact that we have 2 complaints? One filed one day, dismissed, same complaint filed the next day?
Yes, Your Honor, that's exactly what occurred. On March 15th.
Right, but do we actually know that the attorney was forum shopping?
Your Honor, the factual findings of the lower court, when asked in the hearing before Judge Schlesinger, when asked whether the filing of the 2 identical complaints was a mistake, he stated no. It was a design that he filed these 2 complaints in succession.
And then the second complaint, a voluntary dismissal of prejudice, was taken, correct?
Is actually to the first complaint, Your Honor.
The first complaint, I'm sorry. The second's judge.
Yes, Your Honor. After the first complaint was voluntarily dismissed with prejudice, the second complaint went forward. The defendants then removed that case to federal court. Upon an independent review.
What's so wrong with forum shopping?
Your Honor, the state courts, including the 3rd DCA, has condemned the act of selecting between judges.
But if the rule allows you to dismiss a case and refile it, which it does, correct?
Yes, Your Honor.
What did this person do wrong? What did this lawyer do wrong?
Your Honor, Rule 1.420, which is what the appellee uses in this case to say that he has a right to file a case.
I mean, it sounds like a good idea. We get double the amount of filing fees.
I understand, Your Honor.
And the rule allows one dismissal without prejudice and the refiling, correct?
Yes, Your Honor.
And it is expressly so stated in the rule, correct?
Yes, Your Honor.
And it happens routinely, for whatever the motive may be, in the trial courts of this jurisdiction, correct?
Yes, Your Honor. However, case law states.
What's so wrong with forum shopping?
Your Honor, case law states that there is no right to voluntarily dismiss an action if it results in a fraud on the court. Now, a fraud on the court has been.
How can it be a fraud on the court if Rule 1.140 permits you to do it?
Your Honor, in this situation, it was the intent.
Some states allow you to strike judge number 1, correct?
Yes, Your Honor, I would submit to that. However, there are procedures that you may take to recuse a judge and not prefer a judge over one another.
There are also procedures that if the sort of thing that you allege is happening, there are also procedures whereby you can move to transfer the case back to another judge or a judge who had or has a related case, correct?
I would agree, Your Honor. However, in this case,
So what is so bad about what happened here?
Your Honor, in this case, a fraud on the court has been labeled as an unconscionable scheme.
Fraud on the court
Yes.
allowed by the law, correct?
Yes, Your Honor, but it was the intent.
What's a fraud? I mean, they don't try to hide anything. They admit that they were forum shopping, and it's something that's allowed by the rules. I think the one disadvantage to their tactic is that if they find themselves in need to take a voluntary dismissal of the second lawsuit, they would be with prejudice.
I'll agree with that.
So they've given up their right to dismiss the case later on if they have to for the privilege of dismissing it the first time.
I agree with that, Your Honor.
Where's the fraud?
Your Honor, the sidestepping of the random judicial assignments, that is what is used within the Florida courts.
Who adopts the rules in the state of Florida, rules of procedure, rules of civil procedure? Who promulgates them?
The legislator, Your Honor.
No, actually, it's the Supreme Court.
I apologize, Your Honor.
Section 3, Article 5, Section 2 of the Florida Constitution says the Supreme Court. Do you really think that the Supreme Court has, by rule, permitted or authorized or sanctioned fraud on the court?
No, I would suggest that the Supreme Court has not authorized fraud on the court.
So what is your argument?
That the reasoning here for the tactical design of sidestepping the random judicial assignments and selecting between judges would be considered a fraud on the court.
Counsel, let's look at, we've been talking about 1.140. What's the policy or the purpose behind Rule 1.140? Is it to allow you to form shop?
1.1420 does not allow you to forum shop.
That's
No,
not
Your
the purpose of the rule, am I correct?
No, Your Honor, it is not the purpose of the rule.
Okay, so then we have a complaint filed, the same complaint, exact complaint filed the second day. Voluntary dismissal with prejudice is taken the first complaint. You were moved to federal court and you file a motion for summary judgment saying the case has been determined on the merits.
Absolutely, based on res judicata.
Right. And then what happened?
And then after that fact, the plaintiff in the federal court runs back to state court on an ex parte basis. He does not allow the state court, to understand what's occurring in the federal action, nor does he give notice to defendants in the federal
When
action.
everything is said and done, the court had a hearing and determined that there was excusable neglect when they, in fact, dismissed it with prejudice instead of without prejudice. That was a finding of the trial court. You're not quarreling with that finding, correct?
No, the trial court ultimately found that, Your Honor.
Okay.
However, the factual findings of the trial court state that this was a design scheme to go around the random judicial assignment.
All right, so there is no case on point that says that what was done here is not permitted. In fact, it seems to me that the rules allow for this, so they're basically just using the rules to their benefit, it seems to me, and you calling to use the rules to the benefit of fraud on the court, but I don't know that any case has said that. So we would be the first courts to say, by using the rules that allow you to do something, you are defrauding the court.
Your Honor, I would submit that they used, in this case, Rule 1.540 to correct what would be a
Isn't that
tactical
allowed?
error.
1.1, that rule is allowed, correct? If there's a mistake, that rule is allowed.
Yes, Your Honor, but it is not allowed for tactical mistakes.
Well, I disagree.
The trial judge didn't find a tactical mistake. There were affidavits saying this was an error filed by the secretary and the attorney. And there's case law that says if that happens, then the trial courts shall go ahead and strike them with prejudice and allow it to stand without prejudice. Is that correct?
Understood, Your Honor. However, in this case, there was the filing of the two successive complaints
Right.
was a tactical design. Now, what stemmed from that, which was the next step in this scheme, was a voluntary dismissal with prejudice.
But you
Now-
can use the rule voluntary dismissal as a tactical scheme. I mean, if you're in the middle of a trial and you see that one of your witnesses is unavailable and the court is not going to grant you a continuance, you can take a voluntary dismissal even in the middle of trial, as long as the case has not been submitted to the jury. So why is that tactical scheme allowed and not his, which is to dismiss it right off the top and give up their right to dismiss it later?
Your Honor, Rule 1.420 does not contemplate a voluntary dismissal and then refiling it just to get around the judge that you first got in a case and to select the preferred
It
judge.
seems to me that if the Supreme Court doesn't want people to do that, they're going to have to amend the rule. Anyway, you wanted 2 minutes for rebuttal, and we'll give you
Yes,
2
Your
minutes
Honor.
for rebuttal.
Thank you.
May it please the Court. Good morning, Ron Weil. I'll be brief.
Mr. Weil, what really happened here was you kind of got your backside caught in the ringer, didn't you?
Unfortunately,
You filed
in front of all of these people, yes.
You file a complaint, you dismiss it, which you're allowed to do. You file a second complaint, the very same complaint the very next day, which is a little unusual. And then you take a voluntary dismissal with prejudice of the first complaint. All of a sudden, some months down the road, when the case is removed to federal court, you find out you're going to be out.
Correct.
Okay? So then you come back to court. Tell me, why did you file the motion to take off or strike the with prejudice ex parte. Why was that done ex parte?
Because, again, under the rules, no one had been served.
They were a party to the action. They're a party over in federal court. They're named in the complaint. They're a party to the action, and you file an ex parte.
Well, Judge Suarez, just, again, under the rules, as I understand them, if a party has appeared in the action, appeared in that particular action.
Wait. No. You know that there's a party to this action that is represented by counsel. There's definitely unethical behavior to do something ex parte, knowing that they have an interest in this motion, and you are going around that by just doing it ex parte. And you did it twice.
Respectfully, Judge, what we did is look at, I believe it's the service obligations on attorneys, and where a party appears in the action.
But the only reason they didn't appear in the action is because you dismissed it and then refiled it. And
Well,
they have definitely appeared in the second action, and they're definitely litigating the second action. And to say you have no obligation to let them know what you're doing is totally undefensible. I mean, you better argue something else, because I don't buy that for 1 second.
Well, I would just say in brief response, before service, that
I
complaint
know,
could have been
but
dismissed for
that
any
would have
reason.
been fine if you had done it before you filed the second action and they had a lawyer in the second action. If you had gone back and said, whoops, should have been without prejudice, then that would be fine. But after you
Understood.
file the second action and they have a lawyer and they're representing them, and you know they would have something to say about this motion, I think it's indefensible not to notify them.
Understood, Your Honor, and all I can say in what we were trying to
What is the
do.
rule on which you rely to ex parte do what you did?
Well, it talked, I believe it's under motion practice, and under pleadings and service, I believe it's 1.100, Your Honor. Motions and application to the court for an order shall be made by motion and in writing. The requirement of writing is fulfilled.
Doesn't
Sorry.
say anything about not notifying the other party, does it?
No, it's actually under service, I'm sorry. Service of pleadings when required, unless the court otherwise ordered every pleading subsequent to the initial pleading and every other pleading filed in the action shall be served on each party. No service need be made on parties against whom a default is entered, except that pleadings asserting new or additional claims against them shall be served in the manner provided for the service.
That doesn't give you any authority here, does it? You could have served this even if they didn't have counsel upon the party defendant.
I agree. Your Honor, I'm actually not prepared to answer you.
There is no authority whatsoever for you to have attempted to do this on an ex parte basis,
Well,
correct?
No, Your Honor, I wouldn't confess error on that because I do believe under the rules, and I'd have to find it, but service on a party need be made when they appears.
Mr. Weil, as
Sorry?
ordinarily as a frequent appellate lawyer in this court, when you come prepared to argue, you know what rule applies, correct?
Yes, Your Honor.
And you don't have that right now.
I don't have it in mind, Your Honor, but obviously when a party appears in the case, that's when they're served. That was my understanding.
They were served in this case. They were served in this case. And there is no rule. There is just no rule to support what you did, correct?
Respectfully,
There's
Judge,
no rule. There's no rule.
Your Honor, I respectfully demur to Your Honor, but
You briefed this. You presumably researched it as an officer of the court, and presumably you have cited all of the law that should be cited in both directions, as you well know your obligation is, correct?
I do.
And you did not cite in any of your briefs any authority for what you did, correct?
Well, when you say what I did, I believe we did, except as to the service issue, correct.
Well, but not
Well,
only,
that's the key issue.
that's the key issue.
That's the whole issue.
Well, if I can respond just briefly to that being the whole issue, when
I mean, it may be that your paralegal just made a mistake and you didn't read the first problem was your paralegal made a mistake and you probably, in a busy practice, didn't read the dismissal.
which is what the affidavits
And
provided.
your argument is the defense is plain gotcha. On the other hand, when all came to light, it seems to me that if you have no authority, we have two acts that are not very generous, I suppose, is the word that comes to mind. And this is we're here on an abuse of discretion standard, are we not?
I believe so. Yes, sir.
Why shouldn't we affirm? We have two parties.
He wants to
He
affirm.
wants us to affirm.
Yes.
Judge
Okay,
Schlesinger.
reverse, I'm sorry, reverse.
Well, I would just,
I have my,
You would agree, it should be affirmed, correct?
I would agree. And I would just say in defense of what Judge Shepard, you've been asking me about, when the opportunity came to be heard and a motion for reconsideration was filed, there was no request for an evidentiary hearing, so I think we need to get that straight. On appeal, for the first time, there's a request for an evidentiary hearing. Under the
There's not a requirement for an evidentiary hearing based on the pleadings and the affidavits in this case, what you're putting forward.
that's correct. And the leading case, or one of the cases, is Davidson,
Right.
which is the 4th District at 602 Southern 2nd, 687. So the opportunity to be heard was there. All of the arguments that Your Honor's hearing today were heard by the trial judge. What more could
are
be?
we potted plans, counsel?
Oh, absolutely not. I don't feel that way at all today. No.
I'm glad that's the case.
Yes. No, I think Your Honor is asking the right questions. I'm only saying that
I'm glad you think so.
that wasn't meant to be anything other than you're exactly on point. Yes.
Thank you.
Yes. Just briefly then, Your Honor, if Your Honor were to send this back, if Your Honors were to send this back, we would essentially be plowing the same ground.
All right, let me ask you this, because you admit that as a tactic, you filed the two cases and dismissed the first one.
Well, actually,
So-
that was not admitted below, and nor is it admitted here. What should,
Then why was the second, why was this, it's the
The
exact same pleading, isn't it?
you're right. The first action should have been dismissed immediately upon the assignment of the particular judge.
Right.
There was no
So,
intent
but that was
to
a-
have two pending.
No, I understand.
Okay.
But your tactic is to basically form shop, which I'm not sure is prohibited. But for your tactic of filing the two suits, you never would have had this problem in the first place, which is having dismissed it with prejudice. So why can't we just say that this was a tactical mistake instead of excusable neglect?
Because under Randall Eastern, which is the case that's cited by the Florida Supreme Court in Miller versus Fortune, that's an example of a tactical error. In the middle of trial, lawyer announces that he's dismissing the case, intending to dismiss
Well, I
it.
understand that with prejudice was not tactical, but the whole strategy of filing two suits and then dismissing the first one was a tactic. So why couldn't we say that, but for your strategy of filing two suits, you never would have had this problem in the first place?
Well, because I think the issue of whether it's tactical goes to whether the Rule 1.540 should apply, not to the filing of the original actions. So if the two actions, assuming that was a tactical error, that doesn't convert, or assuming that was a tactic, that doesn't convert the dismissal into a tactical strategy.
And what the trial judge below found is basically what you're saying. Even if it was a tactical move on your part to form shop, that's not the issue that was before the trial court. The issue was on the dismissal with prejudice. And I'm gathering the only evidence in front of the trial judge were your affidavits.
That was the only evidence before the trial judge. The opportunity to be heard was fully there at the time. And again, filing two suits was clearly erroneous, but that doesn't make the dismissal a tactical error. Under Randall, it's plainly a mistake, and that's what we're focused on.
How is
Is
filing two, explain to me, because it wasn't in the record, how is filing two suits an error? I mean,
because the first suit. I'm sorry.
You take voluntary dismissal and you file the very same allegations the very next day.
Right, because if we wouldn't even be here had I filed the first suit and dismissed it without prejudice,
Right, absolutely.
and then filed the new suit, and that's what was intended. So the first suit was to be filed, and once assigned, then dismissed. It was not dismissed before the second
So
filing.
then what you're saying is you were waiting to see what judge you got in your first suit before filing.
No, and I'm not saying that. And actually, that's not the case. The dismissal was actually prepared the day of the first assignment. It wasn't filed, but it was intended to be because we had already made our decision.
I'm having a problem understanding. I don't understand how it's a mistake.
Well, because had we done what the rule allows, which is filed the first case and dismissed it, we would have filed on
But the only reason you dismissed the first one is because you didn't like the judge, right?
Well, Your Honor, I wouldn't say that for
What
the
else?
record, but let me put it this way. I do think...
I'm not asking you who the judge was.
I do think when we're trying to decide a complex commercial case, one of the reasonings that would go into any effort to employ 1.420 would be the prior experience of the judge, what business experience and so forth. Those were issues, I think, that at least came to my mind.
All right.
Thank you.
Thank you very much. You have 2 minutes.
Explain to me really, the crux of this is also given Mr. Weil a hard time about forum shopping and some other things that went on in this case. The crux of what we're here looking at is, in fact, the order of the trial judge saying, based on the affidavits, I find excusable neglect. Therefore, I'm going to strike the with prejudice. First case will be without prejudice. Everybody keep going your own way. That's the issue before us. And how do you suggest, or how do you counter that? Give us something to hang on if we wanted to.
Well, first of all, Your Honor, the trial court's factual findings show that it was a tactical decision, and that was a tactical error in the end for the voluntary dismissal.
The decision was filing the second complaint.
Mm-hmm.
You got to put that aside because that really wasn't the issue. Correct me if I'm wrong.
Mm-hmm.
It was the issue, but it's not the issue before the trial judge. The issue before the trial judge was this excusable neglect?
Yes, Your Honor.
And point me to something, because I just see in the record affidavits, which case law is replete on it, where the Secretary of Paralegal says, look, I wasn't supposed to do it, I was in a hurry, I did it inadvertently, and he said, I've got a heavy practice, came across my desk, I signed it.
It's understandable, Your Honor. However, as attorneys, we make tactical decisions in our strategies moving forward.
Right.
If one of those become an error, if we look back in retrospect and say, oh, that was an error, that is what Rule 1.540B does not correct. Now,
What's
the
your
last
best case
step...
for the proposition that something that they did unrelated to the with or without just is a but-for analysis. In other words, but for the strategy of filing two suits, they never would have had this problem in the first place. Is there some case that says that?
There's not a case on point in that in Florida.
Okay.
However, Your Honor, Miller versus Fortune Insurance is what appellee relies on. Simply states that a tactical error cannot be corrected by Rule 1.540.
Well, there was no tactical purpose to dismissing it with prejudice. That just created a huge problem.
It was an essential step in the scheme, though, Your Honor. In
Not
selecting
filing with prejudice.
This was not an essential step in anything. This is all about anything but the merits, isn't it?
Yes, Your Honor. It's a procedural step that he took. Yes,
It's
Your
all
Honor.
about lawyers jousting for position. And if a plaintiff's lawyer makes an error, as lawyers will do over 40 to 50-year career, it's the rare one who steps one foot in front of the other, like Mr. Magoo or whoever that was, right? Then is it not, from an honorable standpoint, some obligation at least for opposing counsel to say, if that is the fact, that the paralegal made the mistake, to say, fine, let's vacate this and get to the merits, whatever it is. Isn't that the honorable thing to do?
I would agree with that, Your Honor.
And you didn't do it, correct?
We never had the opportunity, Your Honor. There was no
You could have-
evidentiary
You
hearing
have
here.
telephones in your office?
Yes, Your Honor, we do.
You could have called Mr. Weil, correct?
Yes, Your Honor, we could have.
Thank you.
But your argument is that this was not a mistake or negligence. There was a tactical error that led down the pipe, and therefore, procedurally, they shouldn't be allowed to do what they're doing.
Yes, Your Honor.
But the problem is that the tactical error isn't really the issue that's in front of us today. It's part of what we reviewed. And my question to you still goes back to the issue before us today is the judge's order saying, I find excusable neglect. Is there anything in the record that we could hang our hat on should we want to reverse that, Judge?
Your Honor, it's simply the admission that he had that it was a design in the first place.
Okay, I understand.
And outside of that, we weren't able to show anything to the lower court to put more things in the record because it was all done on an ex parte basis.
Right.
And at that point, what could we do at a motion for rehearing? It's within the sentiment of the plaintiff as to why he filed successively and whether it was a tactical step in the end. However, we weren't able to show that, Your Honor. It was all done ex parte.
But your rehearing was actually heard before the court, not just summarily denied, correct?
Yes, yes,
Okay.
Your Honor. Yes,
All
Your
right.
Honor.
Thank you.
Thank you.
Thank you.
Counsel.
Thank you.
both.
I will do one more case before the break.